David, do you want me to just jump right into the training?
Oh, yeah, go ahead, I'm sorry.
No worries. You missed it. The PowerPoint, a copy of the PowerPoint is in front of you. So today's training session is just a quick case law update. I have about 7 new cases I thought were interesting enough to present them to you. I don't know if it'll take the full 30 minutes, but we'll see how it goes. So the first case I wanted to bring up is Greenville Fire District versus Zoning Board of Appeals of the Town of Greenburgh. This case was decided in 2022. Funny enough, my firm represented the Greenville Fire District in this case. So I want you to pay attention to the facts that you have on your slide. I'm just going to go through them. This case is about the statute of limitations and whether the petition was filed on time. So I lay out a couple key facts. First, the zoning board of the Town of Greenburgh granted the application of Formation Shelbourne Senior Living Services for certain area variances related to the proposed construction of an assisted living facility. So here's the timeline. On April 20th, 2017, the ZBA, as lead agency, voted to adopt a conditional negative declaration pursuant to seeker. That decision was filed with the town clerk on April 24th. At a meeting held on June 22nd, 2017, the ZBA voted to conditionally grant the requested area variances from the Town of Greenburgh Code, which authorized construction of the project on a site which was less than 4 acres in size and more than 200 feet from a state or county right-of-way. On June 27th, the results of the June 22nd meeting were filed with the town clerk. On July 13th, the ZBA filed a certification of decision which set forth the ZBA's findings. Then, on August 11th, 2017, the petitioners, the Greenville Fire District, commenced the CPLR Article 78 proceeding to annul the ZBA's adoption of the conditioned negative declaration and its determination granting the area variances. So the question is, was the petition filed on time? I'd like the board to take a guess.
Okay.
And maybe I'll give you.
I had a case in the second department that concerned timeliness like 3 months ago. Yeah, so I'm interested.
So just if you're having a hard time making a decision, this Article 78 proceeding challenging a zoning board's determination based on alleged
Certification. Okay, go ahead.
determination based on alleged violations of seeker is to be commenced within the applicable 30-day statute of limitations following a decision that renders the final consideration of seeker issues.
All right.
So it's a 30-day statute of limitations.
So I would, based on the argument I advanced in the second department, I would say no as well.
Anybody else want to opine?
Can
Judy, you said no.
Can you repeat the standard again?
Yes.
The standard is, so Article 78, challenging a zoning board's determination based on alleged violations of seeker is to be commenced within the applicable 30-day statute of limitations period following a decision that renders the final consideration of seeker issues.
It looks to me like that was done
They didn't file
April
the
24th.
certification until the 13th of July, affect that?
So I'm going to say the court said it was timely, but I don't agree with the court.
So you say it wasn't timely, you say it was.
The court in my case said it was timely, and frankly, I thought it was results-oriented, but that's a different story.
So you think the court said it was?
No, well, no, I think on the merits it wasn't.
It wasn't, okay. Montes, any thoughts?
I don't think it was timely. It doesn't sound like it was.
Yeah,
Yeah, April
okay.
24th.
Elaine?
Yes, it was time.
It was timely. Okay, so we're a little split here. So the answer is no. The petition was not filed on time. The Supreme Court determined that the petitioner's challenge to the ZBA's adoption of the condition negative declaration became ripe for review, and the limitations period began to run at the time the ZBA granted the requested area variances. Any such challenge had to be instituted within 30 days after the ZBA's determination was filed with the office of the town clerk. So here, that period began to run on June 27th upon the filing of the ZBA's meeting results, which memorialized the ZBA's determination and recorded the vote of each of its members. Since this proceeding was commenced more than 30 days later, on August 11th, dismissal of the proceeding was proper. So we lost that case because we were trying to argue that it started with the certification of the decision. And the court said, no, it was memorialized in the minutes, and that's when it started. So.
Did
it's
anybody
unfortunate
advance
for-
the position that the decision occurred on, that it became a final decision on June 22nd?
We argue that it became a final decision on July 13th. When it, what? 'cause-
Well, right, but I
yeah,
mean, was the other side saying June 22 or June 27?
June 27th. Yeah, June
Nobody
27th.
argued April 24th?
Nobody argued April 24th. The other side argued June 27th. All right. This case is about special use permit standards. Now, this board doesn't approve special use permits, but I think it's a good thing to know, and we've talked about this in some of our other training sessions. So this case is Manchurian versus Zoning Board of Appeals of the Town of Newcastle. It was also decided in 2022. In this case, my firm represented the Town of Newcastle. So here, the owners of properties that neighbored a rehabilitation facility for disabled and chronically sick children brought proceedings under Article 78, challenging the Town Zoning Board of Appeals determination granting the facility's application for an amended special use permit to expand the facility, and they granted area variances from the requirement that nursing homes had to front a state or county road. So in this case, the nursing home did not front a state or county road. The ZBA granted a area variance from that requirement. The question in this case was, does the ZBA have authority to grant an area variance from a special use permit requirement? What do we think?
I would not think so.
Montos, you said no?
I would not think they had the right to do that.
Elaine, any thoughts?
I'm thinking yes.
Yes, okay.
Yeah.
Yes. David?
I'm inclined to say no, but I'd want to do some actual research on that before taking a position.
Judy, you want to opine?
I would say, since we can't grant special use,
Well, ZBAs can
we used to.
when the municipality gives you the authority.
Right.
You
I think
can
we
grant
used to.
special use permits. So in this case, in the town of Newcastle, the ZBA has the jurisdiction to approve or deny this particular special use permit.
I'm gonna
The-
say yes.
Okay. So, yes, the court said that the ZBA properly granted sunshine and area variance from the nursing home special use permit frontage access requirement. The ZBA has the authority under town law to grant an area variance from any requirement in the zoning regulation, including those for special use permits. So some people argue, and this is what the Manchurians were arguing, is that it's actually a use variance. If you don't meet the special permit requirements, you need a use variance to allow that use. And here the court was saying, no, you can get an area variance for relief from that specific special use permit requirement. In this case, it was about the frontage. And they said that is a reasonable area variance. So there you have it.
In the city of Beacon, that could not happen, correct?
In the city of Beacon, the ZBA doesn't approve special use permits.
Right. But no one could appeal to us a decision by another body, could they?
Yeah, so if the planning board, if there was an application for a special use permit before the planning board, and they didn't meet the special permit requirements,
Yep.
they could come and file an application for the ZBA to get an area variance from that special permit requirement. So the ZBA could still be involved in a area variance pertaining to a special use permit, even if you're not ultimately approving the special use permit.
So if we approved a variance in that instance,
So like in this case, let's say the planning board was the one approving the rehabilitation facility. If they needed the area variance from the frontage requirement, that would be an application to the ZBA, in which case you'd review it in terms of the 5 factors.
Mm-hmm.
Does that make sense? Answer your question?
Yeah.
So it wouldn't be a use variance. As long as that requirement is in the zoning code, you have the authority to grant an area variance from that requirement. If it's any requirement, any other requirement, say it's like a requirement in the noise ordinance, that you cannot grant a variance from a noise ordinance requirement. Does that make sense? Because it's not a zoning code. Your jurisdiction only pertains to the zoning code.
Oh,
What?
I just read the headline of the next one. I got excited.
Yes. Here we go. So this is a case my firm was not involved in. I just happened to find it online. In this case, the ZBA approved an area variance to construct a modest addition to a single-family residence. After weighing the area variance factors and considering the evidence in the record and the public comments presented over the course of 2 public meetings, the zoning board approved with conditions the area variance. The zoning board adopted findings of fact addressing the variance factors, concluding based on evidence in the record that granting the area variance will not produce an undesirable change in the character of the neighborhood, will not be a detriment to the nearby properties, cannot be reasonably achieved by any other method, is not substantial, and will not have an adverse effect or impact on the physical or environmental conditions in the neighborhood. Notice that the ZBA did not say anything about self-created. Did the zoning board's findings lack a rational basis, and were they inconsistent with the law because the zoning board did not make a finding with respect to whether the hardship was self-created? The ZBA didn't talk about it.
I would say, yes, they lack rational. Yes, they lack a rational argument.
Okay,
If
Jordan?
they didn't talk about the self-creation
Okay.
aspect.
Jordan?
No, because it's a balancing test. So it wouldn't have mattered. But I feel dirty saying that out loud, but that is what I think the law is.
David?
I may be taking an overly technical view on this, but I'd say I would be inclined to think that without something indicating that the error was not harmless on its own, it's not reversible.
Okay.
I'm guessing that's not what the court said, though, based on your look.
Nope. I was just scratching my eyes. Montes?
First, I don't think there's enough information for me to say that I think they made an irrational decision, because it really doesn't talk about in detail the public comments, and each case is a case-by-case basis, right? So it's not just a black and white to the 5 questions.
Yeah, that's fair.
So that's how I feel.
Okay. Elaine?
Since you don't have to meet all 5 criteria, missing one would not have made a difference to the outcome.
Great. Everyone, great points. The court said that the 5th factor shall be relevant to the decision of the Zoning Board of Appeals. It shall not necessarily preclude the granting of the area variance. In determining whether to grant an area variance, a ZBA is required to weigh the benefit to the applicants of granting the area variance against any detriment to the health, safety, and welfare of the neighborhood or community affected thereby, taking into account the 5 factors. A ZBA is not required to justify its determination with supporting evidence with respect to each of the 5 factors, so long as its ultimate determination balances the relevant considerations and was rational. Whether a hardship is self-created does not preclude the granting of an area variance, and the ZBA does not need to justify its determination with supporting evidence for each of these facts. The Fourth Department further held that the ZBA rendered its determination after considering the appropriate factors and properly weighing the benefit to the applicants against the detriment to the health, safety, and welfare of the neighborhood if the variance was granted, just like they're required to do under statute. The court further concluded that the record establishes that the ZBA's determination had the requisite rationale. It was therefore an error for the lower court to substitute its judgment for that of the ZBA, even if such contrary determination is itself supported by the record. So I think this court raised some really good points. Even if there's another way to go, if the ZBA's decision is supported, then the court must uphold that decision. It goes back to what we always talk about, is building a good, thorough record, because that's what's going to be the basis for your determination. I think the second thing that really kind of blew me away with this is that the Fourth Department was like, self-created, doesn't matter. A detail I didn't include is that the court was like, obviously it's self-created, without any more details. It's like a one sentence, and this was the only case I could find.
You didn't include that on this piece of paper for me?
I'm so sorry.
True.
Because I knew you'd ask questions. The next question is, why did they say that? And they don't have a reason. They're just like, obviously, this factor doesn't matter.
Now, let me throw it at you this way, because you've read the decision and we haven't. If what was in the record was a substantial amount of discussion and conflicting evidence about whether and to what extent, probably to what extent, better consideration, this was self-created, and the zoning board simply granted the variance, totally ignoring that factor, that might look a little bit different in front of a reviewing court.
Yeah, I think so. I think it just is going to depend on what's in the record and whether the decision was supported. In this case, the court just emphasized how they went through the balancing test and how their ultimate decision was justified. But interestingly enough, I mean, it had to get to the Fourth Department, which means in the lower courts, it went the other way. So it's, you know, we always want to emphasize the importance of building the record and balancing. It's always better to balance all 5 factors, and we do a very good job of touching upon each of them.
But this is 5 factors, right?
No,
A, B.
it's 5, but the 5th factor you're seeing is whether or not it's the minimum variance necessary. The court, put that in their list of factors. That is not technically one of the 5 factors. It's the overarching theme of the variance.
Okay.
Do you think the court felt that way specifically because of that factor, and if another factor was omitted?
Again, I think they'd emphasize the balancing test. It was very interesting that it happened to be the self-created, the one that we always are just like, this is not determinative, and that's, what the court kept saying is like, this factor doesn't really matter. And I don't know if it was one of the other factors. I think that the results would be the same, say, if they didn't talk about substantiality, if there was a clear balancing, and there was enough in the record to, favor granting of the area variances.
It would be interesting to see what a use variance appeal would look like with the same.
Well, and use
Facts.
variance is different because it's not the balancing. And,
Right.
and it's interesting, there's not a use variance case in 2022 or 2021 or 2020 that I came across. I mean, maybe I just wasn't looking hard enough. I did a very broad zoning board search. And I think if you're going to go back and read the decision, because I can picture you maybe not sleeping one night and wanting to read it, I'd recommend reading the Fourth Department decision and also the lower court's decision. There's a lower court decision, while it goes the other way, gives a little more detail and a little more background information, and then the Fourth Department was like, they were wrong. Like, this doesn't, they met the criteria. But, for the sake of efficiency, I'm just kind of giving you like a little taste here. But everyone's points are right. When you look at all the facts, that's what matters. All right, moving on. So this case came out in 2021. It's about zoning board review authority. So On June 6, 2017, and July 12, 2017, the Yonkers Department of Housing and Buildings issued temporary certificates of occupancy to Lowe's Home Center, authorizing limited use of a substantially completed improvement located in the city of Yonkers, specifically in Ridge Hill. I don't know if anyone hangs out in Ridge Hill, where my doctor's offices are. Anyway, the improvement is part of a larger development known as Ridge Hill, which was approved in 2006. The petitioner, a union representing active firefighters of the city's fire department, argued that the mitigation measures identified during the Ridge Hills environmental review included the construction of a new firehouse. The petitioner appealed both temporary certificates of occupancy to the city ZBA, arguing that they were not validly issued given the absence of any firm plans to construct the new firehouse. On October 17th, the ZBA dismissed the petitioner's appeal for lack of jurisdiction. Did the City Zoning Board of Appeals lack jurisdiction to consider the appeal from the union? This one's tricky.
Who conducted the environmental review?
The Planning Board in 2006.
Is that relevant?
No. So I'll move. This one's hard. I think it'll make more sense when of course, after I explain it. Let me jump right into it. In a proceeding to review a determination of a ZBA, a zoning board's interpretation of its zoning ordinance is entitled to great deference, and judicial review is generally limited to ascertaining whether the action was illegal, arbitrary, and capricious, or an abuse of discretion. However, there is a narrow but well-recognized exception to the rule that zoning board's interpretation of its zoning ordinance is entitled to great deference that exists, where the question is one of pure legal interpretation of statutory terms, in which case deference to a zoning board is not required. Here, in this case, the basis for the petitioner's appeal of the City of Yonkers Department of Housing and Buildings issuance of a temporary certificate to the Lowe's was not grounded in the enforcement of any use or dimensional requirement set forth in the Yonkers zoning ordinance. The petitioner instead alleged noncompliance with certain purported mitigation requirements imposed during the seeker process. So what the court was saying is that the union of firefighters could not appeal to the ZBA because they weren't appealing any aspect of the zoning code. They were arguing that, hey, you can't issue this temporary certificate to the Lowe's because we were supposed to get a firehouse instead. And so the court said going to the ZBA was not appropriate. The zoning board had no right to consider that appeal because it had nothing to do with the zoning ordinance.
Oh, good.
Yeah. So once I explain it, like, you're like, oh, okay, that makes sense. And again, if everyone was reading the case, I'm sure, you'd see it. Although it took me a slow read to figure out what was going on. But I think I have some other cases, but I don't really want to rush through because I think they're pretty good. So David, if you don't mind, maybe we can continue this training session next month?
All right, let's do
And
that.
if everyone, you'll keep your packets? Yep. And maybe I'll take another look, see if I can find something else on self-created.
Oh, no, yeah.
There won't be.
It's coming. It's coming. Eventually. You're going to realize.
Well, I think the case that we just saw in the past year or so.
That's a crack.
It was like a little taste of the court just kind of
Things
pushing
go
stuff.
slowly.
Very slowly,